Hey everyone, we are just getting started momentarily as we wait for the room to populate. Thank you so much for joining us here today. I'm just going to give 1 minute here and wait for our wonderful Anna Hickey to give me the thumbs up to actually start the program whenever we get a full attendance all finished and loaded. Great to see so many people here joining us for this discussion, our weekly trials and tribulations discussion.
We are live.
All right. Well, hello, everyone. Welcome. Thank you so much for joining us here again for our weekly Trump Trials and Tribulations session here at Lawfare. My name is Scott R. Anderson. I am a senior editor here at Lawfare. Thrilled to be hosting in Ben's stead, in Ben's shoes, so that he can join us as a guest to talk about some items he's been looking into and watching in the news this week in the Trump trial space. For those of you who may be joining for the first time, this is a weekly program we hold most Thursdays at 4 p.m., almost every Thursday at 4 p.m., barring holidays and other special occasions, to talk about the big developments in the various Trump trials that we are all watching around the country this year and next year. So please come in and join us. You may be watching us on YouTube. If you are on YouTube, know that you can, in fact, join us on Zoom as well, and even have the opportunity to ask a question if you are inclined to do so. If you are a material supporter of Lawfare. So if you're interested in finding out how to do that, please visit us at lawfaremedia.org/support for more information on how to do that and how to join us in person for future sessions to come on and ask your questions or make your comments as you are so inclined. In the interim, if you do have a question or comment, please go ahead and drop it in here. We're going to take them until we begin shifting away from our planned conversation to the Q&A session, at which point we will close the floor for additional questions just for time management reasons. So go ahead and put any questions you might have in the Q&A box now so we can begin prepping to tackle those towards the end of our conversation. Ben, I want to start with you on some of the events of the week, because we saw two big court decisions come down at the end of last week. I think both came after the last Trials and Tribulations session. You wrote a really useful piece on them with our colleague Quinta Jurecic, thinking about the relationship between the Blassingame decision, a decision by the DC Circuit in the civil lawsuit, one of the civil lawsuits against former President Trump arising from the events of January 6th, and its relationship to the decision by Judge Chutkan in the January 6th decision regarding, among other items and possible grounds to dismiss the case advanced by former President Trump, the presidential immunity decision that's similar to the argument, but in a different context, being made in that Blassingame decision. Tell us a little bit about these decisions, what stood out to you, how they relate to each other, and what they tell us about the January 6th case kind of moving forward, particularly the criminal case. And then I want to turn to the recent event that just happened last hour or two that kind of builds on that. But we'll get to that first. First, set the stage
breaking news on this subject. All right, so let's dial your clocks back to last Friday. And the DC Circuit, after sitting on the case for almost a year, or a full year actually, issued a ruling in the case of Blassingame v. Trump, which is a civil case brought by, it's actually a consolidation of several civil cases brought by members of Congress and members of the Capitol Police who claim various types of injuries as a result of January 6th. And among the defendants they have named are the former president. Now, this is a tricky business as applied to Donald Trump, because right around 1980, the Supreme Court handed down a very famous opinion in a case called Nixon v. Fitzgerald, which says basically you cannot sue the president for anything within the outer perimeters of the presidential office. It's called official act immunity, and it basically says the president is immune from civil liability. It does not affect criminal liability. Hold that thought, because we're going to get to the criminal liability question in one opinion. The Supreme Court has had very few opportunities to clarify what official act immunity does and doesn't cover. In fact, it has had exactly one, which is the Clinton v. Jones sexual harassment case, which those of you above a certain age will remember involved conduct that took place in an Arkansas hotel while Bill Clinton was still governor of Arkansas, before he was president. And therefore, in Clinton v. Jones, the Supreme Court said, okay, it is certainly beyond the outer perimeter of the presidential function to sexually harass somebody before you were president. And so all we really know about the scope of presidential immunity is that, first of all, it's very broad. It's anything that can reasonably be considered an official act, with an official act defined as within the outer perimeter of the presidential function. But that does not include stuff that happened before you were president. So that's all we knew until these cases were filed. And I think it's fair to say that everybody expected this to be a divisive issue on the DC Circuit, with presidential power, people taking much more robust views of it than maybe liberal judges. And that did not happen. So this is, in my opinion, the DC Circuit at its very best, taking a highly divisive question on which you would expect people to, go in all kinds of different predictable directions. And the chief judge, Sri Srinivasan, a liberal judge for whom one Scott Anderson once clerked, and a very conservative judge for whom nobody on this call has clerked, Greg Katsas, but who is actually a former Trump White House lawyer. All there are minor differences between them, but on the body of the opinion, they are all unanimous on the material critical questions. And they hold, I think, something that is really quite devastating for Trump, which is that you evaluate a president's action for civil liability purposes based on the functional analysis of whether he was playing the president's role, or whether in these cases he was playing the role as a seeker of office. And he is no more immune than, Joe Biden was in 2020 for conduct committed in his capacity as a candidate. And as a way to figure out which he was doing, you do a contextual analysis and go from there. And so if you think about this in the context of post-January 6th activity, where a lot of stuff that Trump was doing was with campaign lawyers, personal lawyers, was really not involving public performance of presidential duties, I think it opens up a potentially very significant set of legal actions against him, most immediately the ones at issue here. Okay, so fast forward a couple of hours after this opinion comes down, and Judge Tanya Chutkan, who has, of course, the DC January 6th case, produces a second ruling, which is on Trump's rather extravagant effort to get the Nixon v. Fitzgerald principle, which affects only civil, not criminal cases, to apply to criminal cases as well. And Trump had moved to dismiss that indictment on the grounds that everything he did was an official presidential act, and Nixon v. Fitzgerald actually should be applied in the criminal context too. Now, there is virtually no support for this, and Chutkan rejected it in very strong terms. I don't think that's any surprise. I don't think any district court was likely to accept this. This is a doctrine that, if it's going to be promulgated, is really going to be created by the Supreme Court. And so I don't think a lot of analysts were expecting Judge Chutkan to do anything other than what she did. But now, to bring us up to date to right now, a couple of hours ago, Trump filed a notice of appeal to the DC Circuit. He is, for technical reasons we can go into in the Q&A if people want, entitled to an immediate appeal of this. And he not only noticed that immediate appeal, he also asked for a stay of all the proceedings while that appeal takes place. And the significance of that request is that he claims that a stay is mandatory and is a matter of the jurisdiction of the lower court, that the Judge Chutkan lost jurisdiction over the case the moment he appealed it, and that because this issue is one of whether he has to face trial at all, it is one on which a stay is mandatory. And so if the DC Circuit or the Supreme Court agrees with him about that, and I expect the government will resist it, but if they agree with him about that, that could put in jeopardy the March 5th trial date for this case. So that kind of brings us up to speed. I'm not sure if you want me to go into any more detail on any of those points, but that's the overview.
Well, I want to come back to today's filing, but let's spend a minute on the two immunity decisions that we planned to talk about 2 hours ago before we found out about this new filing that came in today. Tell us a little bit about the relationship between the two. Obviously, the blasting game case, civil case, different sort of immunity or different context for immunity, even though the constitutional grounding of it is more or less the same, which is about interference with the office of the president. What is the relationship between the two? What do you anticipate there being a degree of transfer from the blasting game decision, which of course is by the same court that is going to hear the appeal from Judge Chutkan's decision? What is that precedent, which presumably Judge Chutkan didn't have more than 30 minutes to review before she filed her opinion, if she even saw it come down? What can we take about how this court is likely to view her opinion on appeal, do we think?
So I think the DC blasting game indicates that the DC Circuit is going to be a very unfriendly forum for Trump on appeal. That may not matter all that much because the DC Circuit is a way station to the Supreme Court if the Supreme Court wants to hear this, but it may not. And so, the DC Circuit could end up being the last word. And candidly, it's very hard for me to imagine the Supreme Court, the DC Circuit saying out of one side of its mouth, hey, Fitzgerald immunity is a bit narrower than you thought. And, y'all thought it applied to all kinds of things that the president might do. But we're here to tell you when the president acts in his capacity as a candidate, he's not covered by presidential immunity, and then turn around a week or two later or a month or two later and say, oh, but by the way, it also shields him from criminal liability, right? That would be a very strange pair of rulings. So I think on the merits, it indicates that Trump has a very hard row ahead of him at the DC Circuit. I don't think it says anything about what it's likely to mean at the Supreme Court if the Supreme Court wants to consider the matter, except for one thing, which is that, usually cross-ideological, unanimous DC Circuit opinions where there is no conflict in the circuit are the least amenable to cert. I mean, justices tend to look at an opinion that has Judith Rogers, Greg Katsas, and the chief judge, Srinivasan, and say, that comes to the Supreme Court with a very heavy presumption of intellectual seriousness and being right as a result of the diversity of people that you have philosophically on the same set of ideas.
I think that's right. I'd also know Judge Srinivasan is one of the savvier people about kind of framing arguments in a way to avoid reversal on appeal, including pushing the envelopes a little bit where warranted. The fact that he authored that opinion, I think, is indicative as well, even though you had the two concurrences. Excuse me, sorry. Tell us a little bit about today's filing. Like, where do you think that fits in here? Is this just another delay tactic, or is there some merit here? I looked into this a little bit and have some thoughts, but I want you to get your thoughts out.
Yeah, so you're more of the DC Circuit procedure guy than I am, but look, I have read the filing, which is 11 pages. I have not spent time diving into the citations. I think I would be very interested to see how the government responds to this. And my instinct is that the government's response is likely to be that, first of all, Trump is correct that a trial cannot proceed before this issue is resolved. That you are, in fact, when you're asserting immunity, it's immunity against trial, not just an immunity against a finding of guilt, right? It's not simply a defense. It's an argument that, hey, I could shoot somebody on Fifth Avenue, and if this immunity applies, it doesn't, you don't get to try me, right? Think of diplomatic immunity, right? It doesn't matter if the guy's guilty, he's immune and he doesn't face trial. And so the question's going to live or die in the issue of, can you do the pretrial stuff while the DC Circuit is thinking about this? Or, can you continue giving Trump his discovery? Can you deal with pretrial motions so that when the DC Circuit rules and when the Supreme Court rules, you're kind of ready to go? Or do you have to freeze on everything? And honestly, I have not studied the case law that they cite to figure out what the rule is. And by the way, it's not clear to me that the rule that they're citing would apply here, because since the contours of presidential immunity are completely unknown, if it exists at all, which Judge Chutkan says it doesn't, how do we know that the rules that apply to certain other immunities would apply here too? And so I think the answer is, like, we should probably wait until the government files its response, and then the DC Circuit's going to do its own thing with it. I wouldn't be surprised if they did put a stay on it, or at least on some parts of it. But I'm curious what you think, because the ways and the wily ways of the DC Circuit better than I do.
I don't know if I would say that. I can't say I've encountered this issue before, and I'm not sure the DC
Yeah, I
Circuit
don't
has
think
either.
many people have encountered
No. But it's interesting, the move that the Trump team is trying to make here, and it's notable. It's, I think, a little bit of a flash of trying to make a more controversy of this case, because they make a very aggressive argument and then have a fallback argument that's much more reasonable, as is their way in many of these things. Their more aggressive argument, the one that's getting a lot of kind of immediate reactions on Twitter and other places, is that the court, Judge Chutkan, has no option, that she is obligated to stay lower court proceedings while this appeal goes on. To make that argument, they cite Coinbase, a decision from this past term in the Supreme Court that basically interpret a statutory provision relating to arbitration to say, well, when somebody's appealing a denial of arbitration under the statutory provision allowing for interlocutory appeal, it mandates a stay of the matter until that's resolved, because the whole point of determining arbitrability is whether the whole matter can proceed or not. And it interpret that intent into the statutory provision, which is silent on the question, and overruled a district court opinion that had allowed certain aspects of the case to proceed even as arbitrability was being appealed. That was really controversial. It's worth noting that's a 5-4 opinion. The three liberals or Democratic appointees on the court and Justice Thomas joining with them in a not as unusual move as it may sound if you follow court procedural stuff the last few years, objected pretty strenuously and said, you're just making up the law here, Justice Kavanaugh, who wrote the majority opinion. So it's a pretty bold move to take that, which is a very context-specific statutory argument in a very different context, arbitration, and then porting this over to this very different context of presidential immunity, substantially common law immunity, or at least kind of a constitutional, principles-based immunity, not a clear statutory intent question. And this applies in the same way. That said, their fallback argument is essentially that, well, applying the court's discretionary standards of staying, they should still completely stay the matter. I kind of suspect they have more of an argument there, but completely stay, what does that mean? Does that mean the government can't go ahead and hand over a bunch of records to former President Trump? I'm not sure it does. I don't think it would be, the best. It seems like Trump might be hoping to get out of this as an argument that they have to push back the March trial date, because even if they still get the records from the Justice Department, they can't be obligated to review them. But maybe the judge buys that. Maybe the judge says, no, actually, in that trial date, I take into account the potential for an interlocutory appeal because we knew this was a possibility going into this. And clearly you were going to appeal around presidential immunity. So we don't need to just pad time on here if the actual issue is resolved by then. So long story short, I'm not sure it's actually as big a deal filing as I think some of us thought it was initially. I suspect the boldest arguments might not go anywhere, but some of the other lower hanging arguments might find a little grip some places. Let us now go to another. Oh, sorry. Go ahead, Ben.
One other thought on that. How much it matters if there's a stay is almost entirely a function of how quickly the DC Circuit deals with the case. And one possibility is that, this is a lengthy litigation, that this is something that judges take seriously at the DC Circuit level, and then it goes up to the Supreme Court and they take it seriously at the Supreme Court level. Another possibility, though, is that the DC Circuit takes a quick look at this and says, presidential criminal immunity, are you joking? And deals with it in a highly expedited proceeding, yielding a unanimous quick opinion that the Supreme Court relatively quickly denies cert in. And so I think, how significant the question of a stay is with respect to the March 4th trial deadline is almost entirely a question of the timeline of the appeal, about which the range can be, in recent DC Circuit practice, super, super fast in the case of some of the
overnight in some cases.
Yeah, overnight, literally in some cases, or as in Blassingame, a year. Right. And that's just at the DC Circuit level in the Trump cases. And so I think, a lot of people this week are going to tell you they know what's happening in this case. And I'm going to tell you I don't, and neither do any of they.
Fair point. Fair enough. Well, let us go to another part of the January 6th criminal case. Roger, I'm going to come to you for a little bit because we got some interesting filings this week pointing to some new evidence that the special counsel suggesting they're bringing forward that sheds light on new aspects of the case, how they're building their case that we didn't have insight into before, that wasn't self-evident on the face of the indictment, or at least maybe confirm some thoughts we had on the basis of that. Tell us what we learned this week, Roger.
Yeah, the prosecution filed what's called a 404B notice, and this is whenever you want to introduce evidence of that the defendant committed some other crimes or wrongs than the ones he's formally charged with in the indictment. And so the indictment alleges conspiracies that lasted from November 14th to January 20th. 2020 to 2021. So if you're going to introduce evidence outside that window, you need to file this notice, and that gives us a peek at what they're going to introduce. And the reason you do that is you can't introduce this stuff to smear the defendant or to try to show bad character or a propensity to commit crimes. You can only use it for certain permissible purposes, like to show intent, to show a plan, modus operandi, that sort of thing, motive. So that's why they lay this out. And in the course of doing that, there's some things we probably did anticipate, like they're going to show that he floated baseless claims of election fraud in previous elections, including 2016 and even in 2012, which I hadn't remembered. Apparently, he claimed that there were voting machines flipping votes from Obama to Romney, which is one I hadn't remembered. But and then there are also they want to show the early refusals to commit to a peaceful transfer of power. You probably remember that from the September 2020 debate. He did that also in the October 2016 debate. So they want to try to introduce that. But this was a really interesting one, was to show, they say to show knowledge that he knew he'd lost. They apparently have evidence that someone they call an unindicted co-conspirator, and they don't mean one of the six who's named in the indictment here. It's a campaign employee, And they said that on November 4th, so, right after the day after the election, somebody, this campaign employee is texting with an attorney in Detroit, an attorney with the campaign who's coordinating at the TCF Center in Detroit where they're counting votes, and apparently or allegedly instructing the person to they see that the trend is that Trump is losing, and the count is going to go toward Biden, and he encourages a riot. That's the allegation, and there's a lengthy portion of this, and of course, something resembling a riot does then occur, very aggressive individuals making baseless challenges, and and there's quite a passage that's redacted, so that's quite interesting. And then there's also claims of retaliation against the people that were undermining his claims, which continue outside the parameters of the conspiracy. And Trump and unindicted co-conspirator one, which is Giuliani, it's alleged retaliated against the former RNC chief counsel, which I think is Justin Reamer at that time. It was published at that time that he was debunking the idea that Trump that there was election fraud. So apparently there was pre and post attack conspiracy attacks on him, according to the government. The remaining ones we were sort of familiar with: pre and post conspiracy attacks on individuals, sort of like the attacks on Ruby Freeman and Shay Moss. Those came out in the context of the gag order litigation. But one of those was as late as December 2022, after the January 6th committee report came out. He called, I think, either Ruby Freeman or Shay Moss or both treacherous monsters. And then there's finally the post-conspiracy support for the rioters, which you see, he's praised this January 6th choir, the group in prison that sings, I don't know, America the Beautiful or something. And it's composed of highly violent criminals from January 6th, including the guy that sprayed Brian Sicknick the day before he died at the age of 42 of 2 strokes. And he also has said that Enrique Tarrio, the Chief Proud Boy, was horribly treated. So these sorts of things they want to put in. That too, we'd seen some of that in their response to a motion to strike that Trump had filed, but it's pretty interesting material.
Do we get a sense from these that the special counsel's argument is departing or maybe a little different than what we might have expected from the indictment? We all participated in a big write-up about where we thought the case might be going. I think 2 write-ups, technically. I think we had to break into 2 pieces. Is there anything that new in terms of trajectory or new focus here, or is this just kind of a deeper level about how they're building the case we were expecting?
I think it's more of some of the details. We've seen the similar strategies, at least, if not the exact same information presented by the January 6th committee, and also in the recent Colorado trial, trying to oust, keep Trump off the ballot. You go back and show the pattern and practice of how he behaves and so on. So I don't think so, but there were these details I didn't know, and it does show that they seem to have a sort of a deep bench of witnesses here that I didn't know about.
Well, it's certainly interesting. A few other small developments we don't need to spend time on, but we'll flag for people here about in the January 6th case. Here in DC, we've kind of seen a number of news stories about the fact that jury notices appear to have gone out that would be setting up a potential participation in this trial, causing a small stir, certainly locally among those of us who might be in the jury pool. I have not gotten one of these, thank goodness.
I feel so left out.
Having just
Like,
done my
I
jury duty
totally want
recently,
that
I'm
jury
thrilled not to have
questionnaire.
that to do it. And another note, we are still waiting on the DC Circuit gag order opinion. This is the appeal of Judge Chutkan's gag order, which has been pending for a while. As Ben already hinted a little bit, DC Circuit sometimes moves very fast, sometimes moves very slow. If they're moving a little bit slower, particularly on an urgent matter like this, it does suggest that there might be a little bit of disagreement, or people might be writing opinions beyond a short agreed opinion upholding the district court. It doesn't seem like that would take a lot of time to work and ponder and discuss. Although maybe, who knows, people might want to frame it a particular way. So it might not be a good sign of things to come there for Judge Chutkan's opinion as written. Doesn't mean they're not going to get the same place, just might need to approach it differently depending on the panel and the judges involved. Let us turn our eyes now a bit further south to the state of Georgia, from which you may be joining us, Anna Bauer. I actually don't know your current location, perhaps Georgia vicinity. Tell us a little bit what has been happening this week. We had a big hearing on Friday, December 1st, this past Friday, that gave us a little bit of more perspective into where the case is likely headed and when. That hasn't gotten a lot of attention. Tell us about what we learned from that hearing.
Yeah, so this hearing, which I should say, I am joining you from Georgia, from the famous World Book Encyclopedia Library at my parents' home in Georgia. Yes, there was a hearing on Friday that has not gotten a lot of attention, maybe because it was about 6 hours long. I like to think of it as smorgasbord day in Fulton County, because there was this just the number of motions that Judge McAfee wanted to get through argument on. There was a revolving door of defense attorneys who were, going up to the lectern to make argument on these motions. But I think the most notable thing about this hearing is that it was the debut of Steve Sadow, who is the attorney who is Trump's attorney in this case, replaced Drew Findling earlier this year on I think it was the day Trump was indicted. And we haven't really seen a whole lot of him, in terms of making actual arguments. He's been adopting a lot of arguments in the case that other defendants have been making. And it was his first appearance before Judge McAfee. So that in itself was notable. But what happened during the hearing in terms of this discussion about...
Are we not going to hear about his boots?
Oh, they were blue. So I have sent an email to ask what exactly, what the leather or the exotic beast that he had on his feet that day. I do know they were blue, but I can't tell you anymore about whether or not they were ostrich or caiman alligator. So I feel like I'm really losing out on my Steve Sadow's cowboy boots scoops that we've really had a string of exclusives about here at Lawfare.
Although this one, I gotta say, the blue boots, we got beat by the Atlanta Journal-Constitution this week on the color of the boots, and next thing you know, we won't be first in line.
Well, look, they can take the boot scoop, but they will not take the first position in line. I can tell you that. So watch out, AJC, at the federal court removal hearings for Mark Meadows next week. Lawfare will be first, I can guarantee you. But no, so what was really notable about this, though, Scott, is that we had some discussion, kind of unplanned, but it was known that this might come up. Of course, as background, the district attorney's office originally asked for a March trial date for this case. We then had all of this, happen with Ken Chesbrough and Sidney Powell, who request speedy trials. They pleaded out, so those trials got canceled effectively because of those plea deals. And then the rest of these defendants have kind of been sitting and waiting to find out when it is that they when it is that they will have their trial. And apologies in the background for the very loud dog, the very large dog that is barking. So, so what we learned in this trial, though, or excuse me, in this hearing, is that Steve Sadow is basically, unsurprisingly, asking for a kind of delay that Judge McAfee should not set a trial date. The state, because of all these other federal cases and the New York case, has asked for an August date. They believe that will go after the DC federal trial that's supposed to happen in March, and then the classified documents case that may or may not happen in Judge Cannon's courtroom over the summer. And so what we had is this kind of discussion where, Judge McAfee was asking the state, would it be election interference to have this trial in August? And the state responded by saying, no, Judge McAfee, it wouldn't be election interference because this is just, the business of Fulton County kind of proceeding as usual. But I will say, I think that they really missed out on some opportunities to make some better arguments. I think in part because this was not a discussion that was necessarily supposed to be raised and argued on the merits during this hearing. But they kind of didn't really have, I think, a whole lot of arguments on the merits of in response to Steve Sadow's claims that this was election interference and that it would interrupt a presidential campaign. That was really interesting. Also, what was interesting, though, is that Steve Sadow made the claim that, and we've kind of been expecting this, that if this case does not go to trial, and if it's not completed by the time that Trump is potentially elected and then inaugurated into office, he said that, that means the state would not be able to try Trump until 2029. So that was, and the reason being that under the Supremacy Clause, he argued, there would be, it would basically be impossible for Trump to carry out the duties of the presidency. So that was, I think, the most, meaty part of the hearing. But Ben, am I missing anything there? I think you listened to it as well.
I listened to some of it. It was 6 hours long. I have a question for you, though, about the connection between this and the stay motion that we just talked about, which is, at some point in this Fulton County hearing, the Judge McAfee asked the DA's office, how many days notice would you need to go to trial? And they said 30 days. And so imagine that tomorrow the DC Circuit slaps a stay on the proceedings in Washington. Do you think one of the things that Judge McAfee may be thinking about is, if March gets bogged down, we know Judge Cannon's not doing anything before May, I've got this nice block of time. Is it possible that we're looking at a 30-day notice? Be ready for trial end of January, guys.
I mean, look, I would be a little bit surprised if Judge McAfee did it that way. I wouldn't rule it out. What I will say is that I think this is one reason why I say I think that the state could have had some better arguments prepared. So, for example, one of the arguments that Steve Sadow is making is that there's going to be the DC case in March, then there will be the Florida case, then there's the New York case. He's making all these arguments that, okay, the earliest it could happen is August, but as you rightly make this argument, Ben, we actually don't really know if any of those trials are going to go. And there's very good reason to think that the classified documents case likely will not happen in May. And so I think that maybe what Fani Willis's, office could have done is at least, said, Well, look, we've looked at it. The classified documents case is X number of months behind. So we should have, at least a tentative date in which, we set it for then. And if the classified documents case happens or whatever, then so be it, and we'll move it back. But, this is a date in which it seems like it's probably going to be free at least. So why not set it for now? They didn't make those kinds of arguments. However, they did raise the question of, potentially setting an August date and then, moving it back if there's some other conflict with other trials. I think that Judge McAfee, though, seemed to at least think that, it's worth thinking about how this all will interact with the election. But to your point, Ben, he did make this kind of comment that I thought was very interesting about having a potential A team and a B team. He was very concerned about the logistics of having, 15 people in a pool for trial, and how kind of nightmarish that would be in terms of even finding a courtroom that could fit all the defense counsel and the defendants in the same room. Not to mention, the things that we've seen in the young thug trial or the YSL trial, which is another very sprawling RICO case in Fulton County, in which they've, it took them almost a year to seat a jury. So Judge McAfee mentioned, maybe severing the defendants into two groups. You'd have, maybe 8 people in one, 8 people in another. And then if there are things going on with some defendants and the 8 on the A team, then the B team needs to just be prepared to kind of take their place and go to trial, in that first group. So I really don't know how he's going to do it, but I think that he's thinking about the same things that you are. I just can't say, I definitely think that the earliest we might get a trial would be March, but I really think it's a stretch to think it would happen then. There would have to be a lot of things that go on with delaying the DC case, and I think Judge McAfee would have to be really certain, that the defense counsel was ready and that they'd had enough time to prepare.
I just think if you have a stay from the DC circuit, and you have a briefing schedule that looks like it's going to buy you some time, and you're Scott McAfee or the judge in New York who's got a short case, right? You can try that case in a few weeks. All of a sudden, you might look at it and say, boy, the first half of this year looks pretty clear. I've been being deferential to those federal cases, but Judge Cannon's sure not in a rush, and the DC circuit's put a big leash on Judge Chutkin. So, why not me?
Yeah, and that may be. I just think Bonnie Willis's office is going to have to make that argument. Judge McAfee's not going to do that sua sponte. So or on his own. So I really think, if they're listening, maybe that's a strategy now that they'll take now that Ben Wittes has raised it. But I think they need to make that argument if Judge McAfee is going to do something like that.
All
Roger,
right,
you had your hand up. Sorry.
Roger, you have anything to add real quickly here? Roger, you're muted.
Yeah. I think the New York, technically, I think the New York criminal case is also scheduled for March at the moment, unless that's been put off. He had said that he would put it off for a federal case, but if the federal case vanishes, I don't know if he'll put it off.
That's a fair point. Well, this isn't the only developments we've got out of the state of Georgia. We've also heard, had an interesting bit of media come out about one of the co-defendants in that case, Trivian Kuti, and some responses to that, or actually a kind of lack of response so far, at least from prosecutors. Tell us a little bit about that case, and that you've been tracking, and what you find is remarkable about that.
Yeah, there was this really interesting, report from the website Midas Touch. They got their hands on a video that was of a Instagram Live that one of Trump's co-defendants, Trevion Cootie, did to raise money for her, GoFundMe or whatever fundraising she had for her legal defense fund. And she, of course, is charged with crimes that are related to this alleged pressure campaign to, allegedly intimidate Ruby Freeman, a Georgia election worker, into admitting falsely that she committed electoral fraud when in fact she did not. And of course, Ruby Freeman, it's known, is going to be someone who is a key witness in with respect to those charges. And during this Instagram Live, Trevion Cootie made this statement that she did not name Ruby Freeman, but she did heavily imply that she was talking about Ruby Freeman. The comment that she made was, there was a lot of context surrounding it that it very much indicated that's who she was talking about. And she said something to the effect of, I'm going to, screw her whole life up. Or I think she said, I'm going to F her whole life up. Sorry about the dogs. She said, I'm going to F her whole life up when this case is over. And that's a pretty, egregious comment to make, especially compared to, some of the comments that Harrison Floyd, another Trump co-defendant, previously made, that then prosecutors sought to revoke his bond as a result. So there was a lot of speculation from legal experts and, I myself expected that Fulton County prosecutors might seek to revoke her bond. There was a report from CNN that they were considering it, but so far we haven't seen any movement on that, which I think is really interesting because, again, while Harrison Floyd, Judge McAfee found he was in a technical violation for making some of these social media posts about potential witnesses, he did not find that he was making intimidating or threats of harassment. But this comment, saying that you're going to F up the life of a potential witness is certainly something that is more egregious, although the volume maybe of Harrison Floyd's social media posts could have been something that kind of tipped the hand of Fonnie Willis's team. But it's just very interesting to see that they haven't made any moves on this yet. I'm still watching the docket to see if anything will happen. It could be they're gathering more information, maybe seeing if there's other instances in which she's made comments that are similar to that. So I'm not really sure what's going to happen, but it's something that I'm looking out for. And a lot of people that I've talked to, who are defense counsel in Fulton County, unrelated to this case, have said that it seems like Fulton County prosecutors would have a pretty strong motion to revoke bond based on that comment that Trevion Cootie made.
Well, certainly something to watch there. Two other developments I'll flag really briefly, just so we can save time. We can circle back in the Q&A if folks are interested there. We, of course, have some news reporting about Ken Chesebro participating not just as a witness in Georgia as a condition of his guilty plea agreement with the government, state government there, but also engaging, or at least stating willingness to engage with investigators in Nevada, Arizona, other states about their fake electors investigations, and some reports about other potential guilty pleas there. People who have pled guilty in Georgia, engaging in similar degrees of cooperation, something that was hinted at in some of their plea arrangements. Something to keep an eye out there in terms of what role they'll be playing. And of course, our own Anna Bauer as a wonderful new piece looking at new angles of the Coffee County case with some additional updates in Lawfare from, I think, this past weekend. Is that right, Anna? In which case, please check that out on lawfaremedia.org for a little bit of a deeper dive there. Happy to circle back on this in Q&A, but let me, just in the interest of time, move on to, of course, our third big criminal trial in the Trump space. That is the Mar-a-Lago case, where, Roger, we've seen a few developments here. In this case, we've seen some arguments about SEPA, and then a series of kind of unsealed filings, giving us a little bit more of a glimpse into some aspects of the investigation in case that we didn't really see before. Tell us what we've learned and how it might bear on the trajectory of this case over the next couple of weeks.
Well, the key thing is what happened yesterday, which is the government filed its notice of what's called a SEPA Section 4 notice. SEPA is the Classified Information Procedure Act. And under section, you remember the government turned over, there are 32 classified documents that are the subject of the charges against Trump, the documents he willfully withheld. They turned those over to Trump because Trump had already, they didn't turn them over, but he has access to them in a SCIF. And they didn't try to keep that from him because he's seen them before. They wouldn't let his two co-defendants see those documents. There's some small additional amount of material where they think that they are obligated to show him, but they want to make redactions or deletions. And Section 4 is the way you do that. And the way it's typically done is you go to the court ex parte, which means without the defendant's lawyers even present in a sealed proceeding, and you show her the documents and you say, here's the sections we think he needs. Here, this stuff here is about sources and methods. It's ultra sensitive. There's no need for him to have it. And then typically what happens is that the defense also ex parte goes separately to the judge and says, here's our key defenses that we plan. And then the judge decides, well, is this fair to turn over the sections that the government has proposed? And Trump is saying, no, even though that's the usual procedure, we want it to be an adversarial procedure. We want to be involved in this whole process. Now, so they filed a motion today yesterday also, that to have this be an adversarial process. And that will be very controversial if it's granted. Brandon Van Grack, a prosecutor in this national security matters, said that they would have to appeal if Cannon grants this motion. On Twitter, he said that. I'm not 100% sure. The motion is actually, first of all, it's a little more. It might be more. It would give the documents only to cleared counsel, not to Trump himself, which is a little surprising. And the argument is, well, you've already given him, at least as sensitive stuff. You're giving him access to at least as sensitive stuff. And this is probably related to that stuff. And we're asking to give it to cleared counsel only. And I feel certain, based on everything Cannon's done, she's going to grant this motion as to Trump. A more complex situation is with respect to Nauta and de Oliveira, who are demanding also to see a great deal of this evidence, and not just their lawyers. They want to see those 32 documents that Trump is charged with, even though they're not charged with withholding anything. And it'll be interesting to see what she does there. If she's going to show those documents to Nauta and de Oliveira, I think that there would have to be an appeal. If she shows these other ones to Trump's counsel, they'll have a tough choice to make. Do they appeal that or not? I'm not sure.
Well, there's one last set of litigation that we saw some events in this past week I want to talk about. Before we do, though, just a flag for folks. Remember, put any questions you might have into the Q&A box. We're going to turn to those next after we get to this last litigation matter. Once we turn to Q&A, we're going to close the door to further questions and answers, just for the sake of time management. So get in your questions you might have in there now. Roger, the last case that we've heard, actually a family of cases, I should say, are ones close to your heart. These, of course, these Section 3 of the 14th Amendment cases. These are the cases seeking to disqualify former President Trump from the presidency by virtue of Section 3 of the 14th Amendment enacted in the aftermath of the Civil War. We have seen a decision recently in the state of Colorado from a trial court that I think we talked about in the last episode of this podcast and this event series. We are now primed for another decision on appeal that we saw a hearing in this week. We've seen some action in some other cases as well dealing with the same issue. Tell us what's happening in the 14th Amendment Section 3 zone this week.
Well, the most important one is the Colorado one because it's already in the Supreme Court, state Supreme Court. And we heard the argument yesterday. It was 2 hours. It was quite interesting. 7 justices, all of them asked questions, lively bench. I would say that, exceedingly subjective. My impression was that at least 2 are leaning toward disqualification, which would be obviously historic, even if it's just them. We've come a long way since, January 6th itself. The other 5 I couldn't read. There were definitely issues that some of them had. I do not think, if you remember, this is the case where the Judge Wallace, actually found that Trump did engage in insurrection, but then she ruled for Trump on the theory that Section 3 of the 14th Amendment, which is the one that bars insurrectionists from office, roughly speaking, doesn't apply to presidents. And that had been considered one of the more outre arguments. I don't think people expected this to be decided on that ground. And I don't think it will be upheld on those grounds. If Trump wins, I think it will be on other grounds. I think it would likely be the ones they seem to have the most trouble with were the most boring issues, the state law, election law issues. Is this procedure? Can you raise constitutional questions through this procedure? Then also there are the federal justiciability, political questions, doctrines, prudential concerns. Prudential is always an ominous word. It means judges are going to punt. The concern there mainly was about chaos and what if Colorado is the only state not to let them on the ballot, or if you have a patchwork. And I don't think the one of the justices sort of jumped in to sort of throw a lifeline to the petitioner's lawyer who was having a little trouble with that question. And he said, well, if we ban him from the ballot, I'm sure it will be appealed and the Supreme Court will decide these issues and we'll have uniformity. So that could be how that's resolved. But, I had gone to in great lengths in an article the day of the argument to try to lay out the argument. How had the Judge Wallace ruled that Section 3 didn't apply to presidents, and to try to say, maybe it's not absurd, maybe it's a little far-fetched, but it's not absurd. And but at least 2, I would say maybe 4 of the justices clearly thought it was absurd, and they used the word absurd. They, one of them was asking, how is it not absurd to say that anybody who engaged in insurrection can't serve except the president or the vice president? How is that not absurd? So I don't think it'll be that argument. Last thing I'll say is that I personally had thought that the there's this issue about whether Section 3 is self-executing. And I think personally, if it goes to the Supreme Court, that might be how they kill Section 3. There's this 1869 ruling called Griffin's case, where a judge says that it's not self-executing, and meaning that Congress has to go out and create enforcement legislation, which we don't have here. And it's not just a judge, it was Chief Justice Salmon Chase, but I
was going to say that.
Yeah, but he was not acting as he was acting as he was riding circuit, so he was just acting as a lower court judge. So anyway, that got very little time, and it was greeted skeptically. But what actually happened, and it was a little sad really, is that that was to have been argued by a scholar named Josh Blackman, and Trump had ceded 10 minutes of his time to Blackman, who also wrote an amicus brief on behalf of his colleague Seth Tillman. And those guys have made a lot of done a lot of scholarship about the self-executing question, as well as the other question about why Section 3 doesn't apply. And he had to pull out on Monday because of a family conflict. So we hope everything's okay with him. But I think it actually could have hurt Trump's argument that he had to pull out, because the regular lawyer was really not prepared to discuss that very much.
Well, we are waiting with bated breath for the decision out of the Supreme Court in Colorado. Obviously, there's some other matters churning.
Which is going to happen fast, right?
What's that?
The Colorado Supreme Court is supposed to rule quickly, right?
It has to. The ballot, the primary ballot, has to be certified January 5th.
Before then, at least, although obviously there could be an appeal from there, as the court itself noted. So it's a tight timeline on all fronts.
One last thing I'll mention is a new case was filed today in the Oregon Supreme Court directly. I haven't had a chance to comb through that. But obviously, if it starts at that level, it's got a better chance. Also, it has lawyers involved. A lot of these cases, there's been 33 of these cases. Only 4 of them are brought by lawyers, by attorneys. So these are among the more serious cases.
Well, we will be keeping an eye on those cases. One other universe of cases we're just going to touch on super briefly before we go to Q&A. Of course, we've seen some updates just in some of the fake elector prosecutions, something we're beginning to watch a little more closely here at Lawfare. We saw a plea agreement in Wisconsin over a civil suit against several of the fake electors, led by a number of groups, including the Institute for Congressional Advocacy and Protection at Georgetown, a group we've done a lot of work with in the past and are friends of ours. They successfully got a plea agreement out where, in exchange for waiving any monetary damages, some of the fake electors there conceded that they should not have, in fact, been electors or pretended to be, and that Joe Biden won the election. And we saw charges filed in Nevada against several fake electors by a grand jury there. We also know there are ongoing investigations in Arizona, Michigan, and a number of other states as well. So more likely to follow. In other words, the universe of Trump trials and tribulations only continues to grow as time progresses. But for now, that is all that is fit to print or fit to talk about for this week. The floor is now closed for questions. Let us turn to some of our first questions. Julia Cooper, why don't you throw us our inaugural question and we will provide some inaugural answers for you this week.
Okay. I read through Jack Smith's recent 404B filing. And one thing, and I've looked it up and I still am not clear on the difference between intrinsic and extrinsic evidence as he uses it in his filing. Can you discuss that, please?
I'll try, and maybe Scott can correct me, but I think that some evidence is it's sort of in the process of proving the charge crimes themselves you bring in evidence that it's directly relevant, and but it happens to be another crime as well that isn't charged. So that would be intrinsic. But if you're talking about, something he did in 2016, that's clearly extrinsic. It's way outside the conspiracy period, and that's what they're getting at. Does that sound right? Or maybe Anna, who's been in law school more recently, she remembers.
If I ever knew the answer to this, it has long since left my brain. Anna, have you thought about this more recently?
Roger, I think that's basically right. It's because 404B prohibits, the admission of certain types of evidence that would show, Roger explained before, like you're trying to show bad character or other acts that are previous crimes, for example, that someone's done. And that 404B typically prohibits the admission of those things. But 404B, that prohibition doesn't apply if it is intrinsic evidence. It only applies to extrinsic evidence. So things that aren't, part of the same transaction or the same conspiracy that is itself charged within the indictment that prosecutors, are trying to prove up.
I'll give you a simple example. I'm sorry, Anna.
No, go ahead.
A simple example. It came up in the January 6th cases a lot. They would have video of the guy in a restricted zone inside the Capitol, breaking the law, and he'd be smoking a joint. And well, smoking a joint is a separate crime, but they're showing him committing their crime, the one that's charged. So it's not an issue. That's intrinsic.
Very useful. Thank you. Auntie, what do you have for us this week?
Yes. Hello, good evening. So what are the panelists' favorite singers in the Judge Shotgun decision? And I have another. Would you like me to shoot that off?
Let's give us both up front and we'll take them together.
Yeah. Okay, so the second one is looking back to the beginning of these trials, could all panelists name one thing, just one thing that has really, really surprised them in either the DC, the Fulton County, or the Florida trials to date? Thank you.
Well, I will start with the latter because I cannot say I remember any specific zingers from Judge Shotgun's opinion with the specificity to repeat them, unfortunately. I recall there being a little bit of attitude, which is always fun, a little flavor to throw in there. The thing I am most surprised by is elements of the Mar-a-Lago case. And that is simply the amount of information we've gotten about Trump's own interactions with his lawyers. It's really exceptional to pierce attorney-client privilege in this way. And the fact that it seems to be playing a pretty central role in establishing Trump's mens rea, right down to something I know we're going to talk about maybe some of the other questions, Jennifer Little's recent or reports of Jennifer Little's testimony that she gave the grand jury about having expressly warned him about not complying fully with the FBI subpoena and the legal consequences. That is pretty damning stuff. And I've been surprised and shocked a little bit by such clear evidence. He got such clear legal advice and chose to proceed down an alternate route anyway. That is pretty damning and going to be a problem. Again, I remain convinced obstruction in the Mar-a-Lago case is the #1 source of actual legal jeopardy for former President Trump, just because it's so open and shut. Anna, how about you? What jumps out at you on these?
I mean, I won't forget the moment that I found out that Judge Eileen Cannon had been assigned again to Trump's case in the classified documents, obviously in the criminal case versus the civil proceedings. But, I spent hours and hours trying to figure out, how that happened and what the percentage chance it would be. And it just seemed like it was one of those you cannot make this stuff up kind of moments. It was really surprising to me because I just did not expect that twist. Especially because at the time, there was so much confusion around where was it, Miami, was it a Miami case? Was it a West Palm Beach case? Which division? That kind of thing. So that was really surprising. I also was very surprised when we were in our morning editorial meeting and all of a sudden Sidney Powell was pleading guilty, and I just, shouted out, "I gotta go! Sidney Powell's pleading guilty." And that was just surprising because she had made such a name for herself as kind of a true believer in election fraud. I don't think it's surprising when you actually look at the incentives and the kind of way that her defense counsel approached the case. But it was just a little bit surprising seeing someone who had been so integral to, making false claims about the election that she truly seemed to believe. So that was surprising. So that's just two things, and I'll stop there.
Ben, how about you?
So I'm going to confess something, which is that I hate zingers from district judges in general. I love district judges who write always in the super restrained, just answering the question in front of them, not trying to figure out what's going to be the quote in the New York Times. And one of the so Chutkan had some good zingers about kings and presidents being above the law, and about whether presidents should have to think about whether they are going to be immune from crimes or prosecuted, and whether that's a good thing or a bad thing. I have come to dislike that kind of rhetoric in district judges, and I really admired the tone of the DC Circuit opinion in Blasingame, which was completely devoid of any of that. It was just a technical analysis of the issue. And so my favorite zinger in the Chutkan opinion is the part where she didn't do that, but where she just analyzed the issue, which is most of the opinion, by the way. As to the part of this whole thing that has really surprised me, I have joked about this a bunch of times, but it is the performance of Scott McAfee, who let's just pause a minute about this, because he's like gets my MVP for the entire Trump trials right now. Imagine that 2 years ago, you are appointed a state court criminal trial judge in Fulton County. The last thing you are thinking about is, oh, I'm going to have, a RICO conspiracy involving the former president of the United States to overthrow the election. And with 18 co-defendants, from, some guy who tried to intimidate a poll worker to the White House chief of staff, right? And this is the last thing on your mind. You're thinking you're going to have some murder cases, you're going to have some garden variety fraud, you're going to have some robberies, and then this case drops in your lap, and you're 33 years old. You've been a prosecutor for a few years. You're a brand new judge. And I mean, all jokes about his bar mitzvah aside, this guy just picked up the case and he has just done a spectacular job. It is way harder than anything Eileen Cannon is dealing with. It is way harder than anything Judge Chutkan is dealing with or anything going on in New York. And he has just been fabulous. In a low-key, no bullshit kind of way. There's no rhetoric. And I just think he's been a breath of fresh air and completely surprising. And I love watching or listening to these hearings. There's some great advocacy going on from the lawyers. And I love watching Fani Willis's people, who are just real pros, but this judge is just really worth your time. And so that's my big surprise of the whole event.
Roger, why don't you bring us home and we'll go on to the next question.
Biggest surprise was about 2 or 3 weeks before Anna's biggest surprise, when I heard that see, I thought the classified documents case, like you, Scott, this is open and shut, this, and then to 2 or 3 weeks before that we found out first, oh, they've started a grand jury in Florida. What's that about? And then, oh, they're going to bring it in Florida. And that was the gut kick. I didn't know she would be the judge, but I knew who the jury would be. And the whole thing changes. So that was the biggest surprise. And then Zinger, I mean, I thought that Chutkan's opinion was really terrific because, but the part that I liked the most was she makes the analogy to the Washington's farewell address, and you know, Washington is leaving unexpectedly, voluntarily after 2 terms. And that's really unusual in the late 18th century for a leader to do. And he's saying as he goes what he fears. And he talks about all obstructions to the executions of law constitute threats to everything he's built. And then there's that famous line about cunning, ambitious, and unprincipled men will be enabled to subvert the power of the people and to usurp for themselves the reins of government, destroying afterwards the very engines which have lifted them to unjust domain and dominion. And she writes, in this case, defendant is charged with attempting to usurp the reins of government as Washington forewarned. And so it's not gratuitous. These are the stakes. And if you make him immune, we're done for. And so I thought that was very powerful.
All right, Mary Lou, what question do you have for us?
Hey, everybody. So I should just let everyone know that I'm Devin Nunes' lawyer, if you don't recognize my name. So I just wanted to ask a question about our favorite judge, Eileen Cannon, since she doesn't seem to care about the documents case. Why does the government not bring similar charges in New Jersey for the papers that we know he improperly retained in Bedminster?
Okay, so
People
for
know,
those of
you have to
wait,
let me
wait.
answer this, Ben.
Yeah, no, you're gonna answer the question, but there's a word of explanation needed because Devin Nunes' lawyer is not, in fact, Devin Nunes' lawyer. And since lots of people who are watching this, particularly on the live stream, probably don't know Devin Nunes' lawyer from In Lieu of Fun and other live streams, let's just want to clarify that is in fact a very witty pseudonym, not in fact a professional vocation.
Good to know. And I will answer this question because I have been obsessed with the Bedminster proceedings and possibly charges there for many months, as my Lawfare colleagues can testify. It's my favorite angle of this case that never came to fruit. I wrote like at least 2 or 3 pieces about thinking it would, and it never did. I think we actually did get an explanation why in the superseding indictment in the Mar-a-Lago case. What we saw there is that the specific document that we know Trump talked about at Bedminster, which is this document talking about surveillance and ongoing events in a foreign country. I think Afghanistan is what most people are inferring it likely is about, that he shared with outside people. That particular document appears to have found its way back to Mar-a-Lago, and that they actually did recover a copy of it from in response to their search warrant when they searched it. So I think the government likely thinks there's another copy, like they made a photocopy of it or they had 2 copies, and that was at Bedminster. Because we know they provided us a subpoena to Bedminster that they had a big argument, including in front of court, about whether what the response they got was adequate, and tried to push additional pressure on Trump's folks to do an additional search or make additional assertions about what they had done. We don't know the exact details of that. There's all from reporting, but that's what the reporting is. And also reporting is that they considered trying to get a search warrant, but ultimately decided that they couldn't. And I think this is why, because they couldn't say this document is unaccounted for because the copy they have was actually recovered from Mar-a-Lago. We didn't know this at the time of the original indictment, but it became clear in the superseding indictment. So with that, they couldn't really get the search warrant. And my guess is that they just didn't feel like they had enough of a smoking gun to actually prove this. different from Mar-a-Lago. I mean, Mar-a-Lago, part of the reason why it's such a shocking case is because you have pretty smoking gun evidence. You have videos of people moving boxes around the day before the lawyer comes and searches them. 2 rooms where the lawyer was not told they existed, right? Like pretty deliberate effort to obscure with the subpoena there. And I think just absent something that so open and shut, they didn't choose to bring a case there, and they would have had, if they had done it just based off of this testimony from other witnesses about having seen this document and the audio recording we know we have of that, that's pretty compelling. But it also would have come down to like this one sharing and details that is about eyewitness testimony. My guess is it just didn't seem like it was worth the hassle for that one charge they could bring over that one instance. Maybe they still will if some additional evidence manifests, but it just seems like they didn't get what they wanted from the response to the subpoena, and they didn't feel like what they had enough gravity, a combination of gravity and compelling smoking gun evidence to bring that sort of case in such a heated environment. Also in a situation where the office is running on limited resources, has to pick and choose its battles a little bit. So that's where I think we are on that. And sadly, I think it means we probably will never see a Bedminster charges, even though I so badly want to see one and thought for a long time we would see some. Does that sound right? Anna, Roger, Ben, do you have anything to add on that?
I think I have nothing to add to that.
I think there might be a double jeopardy problem too. It's so close. I mean, it's part of this case. I don't see how you.
Now there would, yeah, and I agree. And like now there would be. I mean, I think you could charge it potentially separately if there were another copy or if you recover another copy there. But right now the espionage acts are so broad in terms of the conduct they cover. They very well might be concerned about that. And again, I think in a case like this, you just wouldn't want to run. You want to make everything as clean cut as you can in a politically charged case like this. Jacob, what question do you have for us?
You may have already covered this, but what was the most significant legal aspect of the reporting, over the weekend about Jennifer Little, Trump's lawyer, explicitly warning Trump prior to the subpoena? And happy Hanukkah to all who celebrate.
Thank you. You guys, anyone want to cover that, or I can take a crack at it? Roger, do you have any thoughts on that one?
No, not really.
I can take it.
Go ahead, Ben. Yeah.
Yeah, I mean, look, if you are advised if you are specifically advised that you not responding fully and truthfully to a subpoena and completely will subject you to criminal jeopardy, that is a very powerful potential piece of evidence that you acted willfully and intentionally and knowing that it was illegal. And so there is a lot of that evidence, by the way. And so it may be purely cumulative of other evidence, but this is gold stuff in the hands of prosecutors because it goes directly to the question of intent.
All right. We have 2 questions I'm going to read. This one is from someone who just joined as a material supporter of Lawfare. Thank you so much for joining, Devin. Again, go to lawfaremedia.org/support if you want to become a material supporter of Lawfare, and you can join there via the Zoom conversation to ask questions. Devin's membership didn't come through quite in time to get the Zoom membership, but he sent us a question by YouTube chat, and we're going to try and answer it as he squeezed it in here. Are one of you familiar with the types of integrity requirements required by bar licensing bars that can help explain how Trump and his lawyers might talk to each other to avoid the need for reciprocal disclosure? Do you all have any thoughts on this? This is a very surprisingly technical question, and I need to think it through to think about what exactly you're asking. Ben, Roger, Anna, any thoughts on this one?
I'm not sure I understand the question, to be honest.
Let me see, scroll back up to his longer part of the message. Maybe there's a context that I'm leaving out here.
Could you
I'm not sure I 100%. Yeah, this is what we've written here. One of you familiar with the types of integrity requirements required by bar licensing bars? I think that's just a redundant typo. Can explain how Trump and his lawyers might talk to each other to avoid the need for reciprocal disclosure. I'm not 100% I understand this either. In the interest of us running low on time, Devin, I encourage you to come back next week, ask the question again.
Yeah, so
relevant, and you can explain it to us and make sure we're covering it correctly.
Let's reserve the question for next week, and we'll bring you on and ply you for details of what exactly you're asking, and we'll see what we can do.
Yes, we will make that material supporter status worth its while. We promise. But we may just need one more week to do it. Very last question here from Charles, who had to step away, but we'll ask it in his absence. If Trump is convicted in the Washington, D.C. trial regarding January 6th, may Judge Chutkan immediately remand him to custody of the Federal Bureau of Prisons? The severity of the crimes would seem to require it, while his lawyer will file appeals. His freedom after conviction for a crime of violence, and who has already declared his intention of further lawlessness, seems beyond the pale for any consideration of mercy. What do we think about that? I think, Roger, I'll turn to you on this one, as you are a January 6th trial person today.
She would have that power, but it would be, I don't think you would ordinarily exercise it with somebody that has, shown up and is not a flight risk. And but I don't know. What do you think, Ben?
I think there is vanishingly small likelihood of Trump seeing a day in prison while his appeals are still out. I actually don't have a problem with that. I think he's not a flight risk, and he's not a danger to society within the meaning of the law, although he is a danger to society in a lot of other ways. And so I think the idea that he would be free on appellate bond is commonsensical to me, and I can't imagine that Tanya Chutkan would behave any other way. But, predictions are worth what you pay for them.
For what it's worth, I tend to think that's right. I'd be very surprised if he's immediately sent to prison. All the other factors here, most people when convicted have some time to, of freedom before for a sentence, let alone while they're awaiting sentencing. I think that seems unlikely here. So, but maybe for President Trump, we'll do something that changes that in the weeks to come. We will have to wait to find out. We will have the opportunity to talk about that further on a future episode of Trump's Trials and Tribulations. Until then, we are done for tonight. Please check in next Thursday for the next episode of this. I suspect we will take a break sometime this month for the holidays, but it won't be next Thursday. So come back next Thursday, where we'll be talking about whatever happens in the next week here on Trump Trials and Tribulations. Tune into the podcast that this is going to be turned into in the next day or two on the Lawfare podcast feed. So be sure to check that out, and be sure to visit lawfaremedia.org/support to become a material supporter, so you can join and ask us questions and come on and join us in the conversation in future weeks. Until then, thank you, everyone. Thank you so much for joining.